Hello everyone, welcome to the US Update Immigration. For many families waiting on a green card, there are new updates on family-based green cards. As we approach November 2025, US immigration policy is entering another turning point. The system that millions of families depend on is about to change, and not in small ways. In this video, we'll walk you through the major family green card policy shakeup expected from November 2025, what USCIS is changing, how it could affect your petition, and what steps you should take right now to stay ahead. If you are liking this video, please hit the bell button, subscribe, and like it so that you may get updates straight to your smartphone. Now, let's get into the video. For years, the family-based green card process has been one of the most stable pillars of the U.S. immigration system. It was meant to bring loved ones together, parents reuniting with children, husbands and wives finally closing the distance, and families beginning their lives in one place. But under the leadership of Joseph B. Edlow at U.S. Citizenship and Immigration Services and renewed enforcement emphasis from the Trump administration, that foundation is being rewritten. On August 1, 2025, USCIS released a series of internal policy manual updates titled Family-Based Immigrant Visa Petition Approvals. So, this new guidance basically gives officers broader discretion in evaluating petitions, reviewing evidence, and even reopening previously approved cases if new questions come up. The change will start to take full effect in November 2025, and honestly, it's one of the largest procedural shifts in family-based immigration we've seen in almost a decade. The biggest takeaway from this update is that, well, an approved petition no longer guarantees a clear path to a green card. Under the new rules, officers can actually deny or revoke a petition if they later find that the beneficiary is otherwise removable. So, yeah, even after approval, your case can be re-examined. This expanded discretion is being framed as a way to strengthen integrity, but in practical terms, it could mean longer reviews, tougher questioning, and honestly, higher chances of requests for evidence or even denials. Families who have already waited years might now face new uncertainty about how their relationship will be evaluated. The second major change relates to interview and evidence standards. Previously, certain family relationships such as spouses or parents of U.S. citizens often qualified for interview waivers. Beginning in November, USCIS plans to narrow those waivers and expand the types of cases that require in-person interviews. More supporting evidence will be requested and more cases will be flagged for additional background checks or field verification. The third change involves visa bulletin timing and processing coordination. The State Department and USCIS will align their filing criteria more tightly, but with stricter documentation checks. That means cases stuck between approval and final adjustment could see new delays while the two agencies sync their data. The fourth change is about fraud and integrity enforcement. Under the Trump administration's direction, USCIS and the Department of Homeland Security are increasing investigations into potential misuse of family-based petitions. That includes random file audits, closer review of prior petitions, and expanded coordination with ICE and the National Benefits Center. And finally, the fifth change, which many are calling the most consequential, concerns timing. USCIS has made clear that the new standards will apply to petitions adjudicated after November 2025, meaning that cases filed before then may still be reviewed under the current less stringent guidance. This makes timing critical. Applicants who are eligible now may benefit from submitting before the new rules are fully in place. Now let's talk about the upcoming changes in November 2025 in plain terms. Starting November 2025, USCIS officers will begin implementing new good faith relationship and eligibility integrity criteria. That means that even legitimate family petitions may need stronger evidence than before. Joint financial documents, long-term communication history, travel records, shared property, and consistent residence history will all carry more weight. Additionally, USCIS is planning to expand biometric and background checks before scheduling interviews. So, this could actually slow down case movement in late 2025 and early 2026 as the agency transitions to the new system. Family preference categories like F1, which is adult children of U.S. citizens, and F3, married children, are expected to face the heaviest review. Immediate relatives, while still prioritized, will also face more documentation requests. If you're currently eligible to file an I-130 petition, or if your priority date is getting close to current, November's rule change means now is really the best time to act. Submitting before the policy shift could mean your case gets processed under today's rules, not tomorrow's stricter standards. It's also worth noting that these updates are being introduced alongside a broader Trump administration effort to increase enforcement consistency and reduce what they call benefit misuse. While the administration frames it as a matter of fairness and integrity, immigration advocates warn that it could result in more delays and denials for families who have done everything correctly. In short, the system isn't closing, but the doors are narrowing. Every document, every date, every piece of evidence will matter more than ever. So what can you do right now? First, check your category. Immediate relatives, spouses, parents, and children under 21 of U.S. citizens will continue to move faster, but they too must meet stricter evidence standards. Family preference categories, which already face long waits, will need even stronger documentation. Second, review your file. Make sure your paperwork is complete and that all details are consistent from addresses to signatures to joint evidence. Third, if your petition was approved but you haven't yet filed your adjustment of status form I-485 or consular paperwork, you should move quickly. Delaying until after November could bring, new scrutiny or even longer processing times. Fourth, if you have any prior immigration issues, arrests, or denials, it's a good idea to seek professional legal guidance. Under the new rules, even minor discrepancies can be magnified. And finally, stay informed. Policies can shift overnight, but being prepared really keeps you ahead. As one USCIS insider recently described it, November's change isn't about new laws, it's about new expectations. The process is still open, but honestly, the bar is higher. Those who prepare well and act early will be the ones who cross smoothly when the rules officially change. That's all we have for this bulletin. The U.S. Update Immigration Channel provides all necessary visa information and procedures for your U.S. immigration journey. It's important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We'll continue to provide all information about U.S. visitor visas such as B1 and B2, work visas like L1A, L1B, and H1B, student visas, green cards, immigrant visas, including EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. If you haven't already, please subscribe to the U.S. Update Immigration Channel. Thank you for watching, and we'll see you in the next video.